Ready, start. The primary issue that has been canvassed by the respondents is that the substantive claims of the petitioner are explicit time barred and therefore incapable of being referred to arbitration. Full stop. The respondents contend that, with respect to the issue relating to the 210 equity shares, the petitioner has sought enforcement of the letter dated 22/9/2011, but has, however, served a notice invoking arbitration 6 years later on 23/1/2017. Full stop. Further, with respect to the 4 lakh equity shares, it was contended that the claim can only arise upon the date of resignation, that is 18/7/2013, and the claim would, therefore, again be time barred. Full stop. Conversely, the case of the petitioners is that the date of 15/10/2015, that is the date of the last legal notice sent by the respondents to the petitioner, can be considered as the date of cause of action for the purposes of limitation. Full stop. In the alternative, they assert that there is no specific date or day on which it can be ascertained that the cause of action had arisen, since there is a continuous breach of contract on the part of the respondents. Full stop. As evident from the aforesaid discussion, this court cannot conduct an intricate evidentiary inquiry into the question of when the cause of action can be said to have arisen between the parties and whether the claim raised by the petitioner is time barred. Full stop. This has to be strictly left for the determination by the arbitral tribunal. Full stop. All other submissions made by the parties regarding the entitlement of the petitioner to 4 lakh and 2 lakh 10 equity shares in respondent 1 company are concerned with the merits of the dispute, which squarely falls within the domain of the arbitral tribunal. Full stop. It is now well settled law that, at the stage of Section 11 application, the referral courts need only to examine whether the arbitration agreement exists. That's nothing more, nothing less. Full stop. This approach upholds the intention of the parties, at the time of entering into the agreement, to refer all disputes arising between themselves to arbitration. Full stop. However, some parties might take undue advantage of such a limited scope of judicial interference of the referral courts and force other parties to the agreement into participating in a time-consuming and costly arbitration process. Full stop. This is especially possible in instances, including but not limited to, where the claimant canvasses either explicit time-barred claims or claims which have been discharged through accord and satisfaction close, are cases where the impediment of a non-signatory to the arbitration agreement is sought, etc. Full stop. In order to balance such a limited scope of judicial interference with the interests of the parties who might be constrained to participate in the arbitration proceedings, the arbitral tribunal may direct that the costs of the arbitration shall be borne by the party which the tribunal ultimately finds to have abused the process of law and caused unnecessary harassment to the other party to the arbitration. Full stop. The existence of the arbitration agreement as contained in clause 13.10 of the shareholders agreement is not disputed by either of the parties. Full stop. The submissions as regards the claim of the petitioner being explicit time barred may be adjudicated upon by the arbitral tribunal as a preliminary issue. Full stop. In view of the aforesaid, the present petitions are allowed. Full stop. Taking into consideration the fact that an arbitral tribunal comprising of a sole arbitrator has already been constituted for the adjudication of disputes between the same parties in relation to the service agreement dated 18/10/2011, it would be desirable to constitute an arbitral tribunal comprising of the same sole arbitrator for adjudication of the present disputes pertaining to the shareholders agreement dated 25/7/2011. Full stop.